6 months ago, lawmaker Akpoti-Uduaghan's outburst in the Senate was beamed into the homes and devices of millions of people across Nigeria, triggering conversations about Senate etiquette and sexual harassment. The lawmaker was subsequently suspended by the Senate after it accused her of violating its rules. She challenged the suspension in court and made an unsuccessful attempt to resume sitting. That 6-month suspension was set to end last week, and in a letter, the senator informed the upper chamber that she planned to resume on September 4. But the Senate has rejected her request to return, saying the matter remains in court, and until the judicial process is concluded, she cannot return. Condemnation from several angles has followed the Senate decision, as well as, of course, those who are saying that the Senate is on the right side. I'm joined now by a member of Senator Akpoti-Uduaghan's council, Ibrahim Wali, and former lawmaker Honorable Obun, who is a former member of the APC Presidential Campaign Council in 2023. Gentlemen, you are welcome to the program. Let me start with you, Wali. The Senate says from the Deputy Clerk, Dan Zania, the Senate says Natasha cannot resume as yet because there is a subsisting court order. Do you have an argument with that?
Most definitely. To begin with, I don't think that it is proper to say that this is the communication of the Senate itself. The Senate, by its standing orders, communicate through resolutions, right? So if there is a position of this nature, they ought to pass a resolution, to present it to its members, to vote on it, and then to pass it on to the clerk for onward communication. The clerk is merely represents, he holds a ministerial and administrative role, so the clerk cannot by himself or, through undisclosed source, decide that is the position of the Senate itself. What do you mean by
undisclosed source?
It says that I was informed.
Of the House.
Yeah, he said that he was informed.
Of the Senate, sorry.
Yes, he said he was informed. So we have no knowledge of who informed him. So if indeed that it was an information or communication of the Senate, then it ought to be by a resolution. That is what the standing orders themselves say, and that is what the protocol of the National Assembly is. So as it is, there is no communication from the Senate.
You were a lawmaker, former lawmaker. You should understand the workings both of the House and probably of the Senate. Is he right?
This is the tragedy of our country, that because in the last 24, going to the 25th year, we have for the first time consistently kept the democratic space on with elected legislators. The legislature of the three arms of government is like the last child. So it is suffering the battering that the elder brothers give, the judiciary and the executive. So the legislature keeps getting this battering. And the worst offenders are those who ought to benefit from the legislature. And that is the public and the voting public. The legislature's duties are governed by the Constitution and its own rules. The Constitution of Nigeria empowers the legislature, whether as councillors, as State House of Assemblies, or as National Assembly, to make rules for itself. Those become subsidiary legislations. If in the rules of the Senate or National Assembly, let's put that completely, the communication, even in your official bureaucracy, under the flying seal of this through that, all communication shall be through this. It's written there, the rules are there. And the clerk of the National Assembly is a constitutional position. He is not there for fun. And he gets information that comes, and the Senate President, or who is the chairman of the National Assembly, communicates to him that this is what we have gotten, please reply, and these are our rules, and this is the law, and this is the Constitution, the ground norm, which you cannot override except through a court order. And the ground norm of Nigerian Constitution tells you that by those rules, which is what the judge said in that judgment, which they want to interpret for the judge, to say, look, you have made your rules. By your rules, you are right. But we think in our opinion, not by our order. In our opinion, it is excessive. You now go back and say, the court said, the court orders, the court does not suggest. Because the judge realized and knew that the powers of court are limited. Where we are now is that the rules and the Constitution of Nigeria holds the hands of the National Assembly from acting on any matter before any court of competent jurisdiction in Nigeria.
Interesting.
No arm of government in parliament can make inquiries, whichever comes first. And I keep making this point. Anytime a parliament takes a decision or is about to make a law or take a decision, no court can inquire into what that is. But the court can stop the decision that is taken. Can say that decision you took is not correct. But when a matter is also before a court, no parliament in Nigeria, whether state or national, can inquire until that matter is disposed with.
Okay.
That is where we are.
Let me, before I come to you, Wali, you will respond to that. Some argue that, yes, rules are rules. But can't rules have a human face? She's representing people, and the people have been denied of representation for 6 months, half a year. So one is wondering, can't rules have a human face?
Now, you are talking about the mark of human kindness and compassion. That is why you see that the Queen of Justice is blinded. He doesn't see the people. He's seeing the man you sent. That person you sent, before you elected him, he was not appointed. He was not imposed on you. You willingly elected him. That means he's fit and proper. If by the conduct
supposedly
of that,
so.
Yes. If by the conduct of that person, he goes into that place and misrepresents what you represent. And the rules of that parliament says, by these our rules, you cannot do this. Yes, on compassionate grounds. But will the rules be bent on compassionate grounds? The law is blind to that compassion.
Wali.
So I will plead that Nigerians should understand that this blackmail is going to kill an arm of government. That is the parliament. The reason is because a parliamentarian can walk into a palm wine shop, can walk into Wuse Market, but the president or governor cannot walk there because the security will bar him. That is why the parliament is the only hope. The people, and therefore they should respect it and protect it more than even the judiciary, because no judge can go to a wine bar. No governor can do that. That is the executive. But when it comes to parliamentarians, if they don't go, he say, look at this man, we elected him, cannot even greet us again. He's winding up and all that. So we want to see that happen. Nigeria must protect the parliament.
All right, Wali, you're going to respond to all that he has said. You're among the council of what I understand. Just add this to it. We're just looking at all the sides to this issue, trying to settle it. Won't it be wise for Akpoti-Uduaghan to withdraw the case from court and take the sails of the wings of the Senate? I mean, take the sails off the wings of the Senate. Won't that be the wise thing to do if the Senate says this is still sub judice and we can't do anything until the court finishes its proceedings?
Well, before I answer that particular question, I'd love to address a thing or two of what he said. He made the comment that the judiciary ought to be respected, and because the court is still at the matter is still at the Court of Appeal, so all parties should maintain, I would like to think, status quo. But this matter was filed on the 4th of March. And then we got a court order, barring the Senate from proceeding with even, the disciplinary committee itself before even the suspension. It was served on them. They went ahead under the guise of parliamentary immunity and disobeyed the court order and went ahead to suspend her. Suddenly they are, taking us back to the court.
Bar the Senate?
Exactly. Yes, from proceeding. Yes,
I don't think the court barred the Senate.
Don't say that.
There was an interim order.
Continue, but I don't think, I just want to.
It was never
Justice Egwatu delivered an interim order barring the Senate from proceeding with the disciplinary committee.
The judiciary, I don't think the judiciary
I'm telling you that it
has
did.
a right
Can you give us?
to bar the Senate from carrying out its own functions, because there are three separate arms of government.
So Section 4, subsection 8 of the Constitution is clear that the powers of the legislator is subject to court.
Never. Please.
You may open the Constitution. I mean, this is national television. It
Yes.
is there.
I would
give you
challenge
the
that.
section.
I would challenge that. I
So
don't need to be a
even
lawyer to
Section
challenge
60 that allows the Senate to, or the
Make
National
rules.
Assembly to make rules, said that the rules are subject to the Constitution. The
Good.
Constitution
And what does the
creates the
Constitution say?
judiciary.
Good. And
So it
creates
means that
the parliament.
yes, it means that the
And creates
standing
the
order
parliament.
is subject to the Constitution, to the judiciary itself.
The
But first of it is very clear as to the fact that their actions are subject to the Constitution.
But when
It
this
is clear.
case, when this
Remember
case,
this matter came up. All your lawyers came on television, went to court, and the courts were clear, and their lawyers submitted to the point. In fact, even the last ruling of this judge, Nyako, was to the effect, because she knew that she could not overrule the powers given, Section 60.
it was advisory. What
Yes,
they said,
it
I
was
remember
purely
clearly.
advisory.
That
It
is
was
that
never-
is how they interpret it.
No,
that
not
was
interpret
what
now.
the-
Let your lawyers go.
interpretation.
You are a lawyer. Why won't you go to court now? Go and ask the court for proper
The
interpretation.
court, I remember, if
Why
I
coming
remember
to make
clearly,
it's
what
not
was said was that I think they said in an
That the suspension was
advisory
overreaching.
matter that the length of the suspension
was much
was much.
on account of
Well,
the
he said that
constituents.
it overreached the Constitution.
No.
No, they
If it said so, it will give an order
Have
now.
you actually studied the judgment, sir?
Yes,
Respectfully.
I have read it.
So
I have
what
read
did, what
it
did,
over
what did
and
Justice Binta
over.
say regarding the suspension?
So why have your lawyers not? You are part of the law.
Okay,
You are part of the lawyers.
let me ask you this.
I've been citing
Yes.
the sections for you anyway. You can go and...
Yeah, we'll check it because of the time. I can't
I
begin to check.
have
But
read
there's just
them.
one thing that I want
can
to
say.
say quickly.
Okay.
Right, so their argument is that, there's legislative immunity, and that is what you just said. So the suspension was proper. The suspension was made, using a resolution. If we agree, without conceding that it was proper, then it means the resolution would have to take, its fullest effect. The resolution said that, it expires in 6 months. So why are they suddenly trying to, step aside their
Let
own
me ask you
resolution?
that. Hold on. Let me
Yes.
ask you that question before I come to the next question. The appeal concerns the legality and constitutionality of her suspension. But the argument is that now she has served her suspension. It has been overtaken by events. I think there's something you call when you're talking about when you want
A fusion of time. What by
yeah,
fusion
yeah,
of time?
status barred.
It is status barred.
When status barred. So, if she has served her suspension, all these other things are they not just? It's behind us.
You
It's
can
like
call it
status barred.
academic.
Yeah, yeah.
You will want to say it is academic.
Is it not?
It can no longer be academic. The reason is because if she had gotten her judgment, she will first of all ask for damages. If she asks for damages on account of the fact that, look, the court said this, which is what he was trying to say
There's
to
a
the fact that...
discretion to ask for damage.
No, I'm saying, if she had done so, if she had gotten judgment,
Yeah.
why was she on the one on appeal? It is not the senior that went on appeal. It
That's
is
why I asked
Uduaghan
if
that
you
went
read
to.
the entire judgment,
Yes, I
sir.
did. And she went on appeal, insisting that her rights were being
Trampled upon.
And the court ruled in favor of the and said, you have a right to do this, but please be compassionate on account of, because of the constituents. That these people are going to be suffering on because of what their own representative is doing. But I ask you, that if that judgment went in her favor, and we went, the Senate or the National Assembly went on appeal, the same effect will apply. But in this case, she's the one who went on appeal.
Let me ask you something.
I was
Let
saying
me
the
ask.
appeal was on
I will
the
come to you.
contempt proceedings
I will come
itself.
to you. This question, he would take it. You would take it, because it also involves what you do. It plays on. The question is this: if the court issue lingers, say till 2026, or dovetails into 2027. Does it then mean that the Senate cannot allow her to resume?
The law says so, not the Senate.
What law, sir?
The law of Nigeria says
So
a matter
what
pending before a
law?
competent court
So
cannot be adjudicated or decided upon by any parliament in Nigeria.
So are you saying, hold on, are you saying that this is 2025, September, if the whole 365 days in 2026 expires, then we'll get into 2027 and the court has not decided, Akpoti-Uduaghan cannot resume?
Let me now give you a foundation upon which Nigerians must now take it. When I came on your studio and said that Nigerians must, and this is what Zik said in 1983 and 1979, that we should have the mental health of our public officers examined before they become ministers or councillors or senators or House of Reps members. The reason is because a simple matter. If you apologize as you are standing there, Uduaghan, Natasha, if you are standing there, if you apologize to this house for this shouting you did, you will just sit back. We won't have anything
Which
to
you
do.
didn't
So
do.
it's about
Two,
ego and not due
they now
process.
told her that. Now, the second thing is that she's gone to court, and the court says what your colleagues did is within their right, and is within the law, and is within the constitution. It's not about the rules of the Senate. It's about the constitution of Nigeria. The courts in Nigeria have said so. And we are asking today, you asked the first question, what does it take her? So she came there for grandstanding and personal gains.
Okay, hold on.
If you're sake of her community,
I'll probably
and her
come
people,
back to you because
she should have by now said,
I don't know.
I'm sorry, and gone back to sit.
But
because it is for herself.
I don't know whether you have answered this question, but I'll get back to you. So that question I raised,
question, yes.
you know, of
So,
yeah.
It is bigger than Senator Natasha. And this is a constitutional issue. Even after this legislature, she can proceed to court to, define, to explain, and to give verdicts, rulings on the legality of the suspension itself. So it is about, the constitutional provisions, the standing orders of the Senate. It's not about Natasha specifically, Senator Natasha specifically. And I would like to mention that the clerk himself, he addressed her as distinguished senator. You remember the resolution?
She's a senator, of course.
But the resolution said that she should not hold herself as a senator.
No,
nobody
her
will.
time, excuse me.
It seems he
all
didn't read it
senators having been
exhaustively.
elected and sworn in.
Even after your
Suspension resolution said
She
that
is a
pending the
distinguished-
suspension, you
Please.
should not hold yourself out as a senator.
No.
It seems he didn't even read the
Excuse
documents
me.
exhaustively.
No, I even want you to address this issue, which I have
But
asked.
it's a constitutional
Let me
issue.
give you
She has the
which
right
I-
to
hold
go
on,
to the
which I've
constitution.
asked-
It's
which
bigger
I
than
asked
her.
him, the issue
So
of-
it's not about
the
apologizing.
issue of what we're
She can continue.
You are
hold on.
It's
Wali,
like when you are
Wali,
detained by
hold
the
on,
police.
hold on.
Let me just make this point. It's like when you are detained by the police illegally, and then they say, and then you go on and file a fundamental human rights action, and then we're advising you to, why don't you withdraw the suit? Why don't you apologize?
But
Otherwise,
it happens, but Wali, hold on, it happens.
Yes,
that,
but the police
that
can't
a
continue
judge,
holding you because you filed a
hold on, it happens that a
fundamental human
judge
rights
can
action.
call both parties and say, go and decide outside of the court. It happens. But what I'm saying is, what I really want to know.
There's a limitation to how,
What I really want to know, which I have asked him, which I'm asking is, supposing, our court systems, supposing it lingers to 2026, Akpoti-Uduaghan is representing people. 6 months, they have not had representation at all. Supposing it lingers till 2026, then maybe till 2027, I want to really know, does it mean she cannot resume in the Senate, even though she has served the punishment?
She should be able to resume as it is currently. Section 68 is clear that the people have to be represented at all times. Even the court made mention of the fact that the duration was excessive, overreaching the Constitution. It's very important to say that.
Yeah, but it didn't force the Senate to...
But if a decision overreaches the Constitution, both the Senate and the court, yourself and myself,
What
are
were the
subject to the
consequential orders,
Constitution.
and why
No,
are
but
you
it
in
depends
appeal?
on what the judge says. But what I'm
Okay,
asking...
why are we in appeal? Why are they? Let me answer this question, and that is why I said probably he hasn't seen the notice of appeal as well, right?
Okay.
So the court said that she was held in contempt and she should pay 5 million naira, and the court also said that their preliminary objection, it succeeded in parts. That is why she's in appeal. Just 2 issues.
We have agreed that
So
she's in appeal. Have you accepted that she's in appeal?
Yeah, but there's an issue.
You are a lawyer.
It's
Can I
scope.
ask you?
Yeah,
Are
please.
there situations in which an appeal acts as a stay of execution?
I mean, if you go into court and you
Excuse
apply
me.
for a stay of execution,
Excuse
which
me.
we don't
Is
have,
there a situation in which our court,
You
our
teach us.
jurisprudence permits that an appeal serves as a stay of execution.
If there is a stay of execution
yes.
application,
If there is, then I ask you.
I don't have any time.
A moral question.
I don't have any time. Yeah, okay.
You're asking a moral question. That will it be fair? I say to you, the people of the central.
It's not about fairness. It's about legality now.
No.
Would it be legal?
If legality does not give you fairness, what are you
but
for?
It's
so I'm saying to you that
the
legality of all of it, the legality of all of it is that a matter pending in court cannot be decided upon by any parliament in Nigeria. That's the Nigerian constitution.
What are the issues?
The Nigerian constitution, whatever the issue is, once it is
whatever
before
the
the
issues
court,
are, it's scoped.
Whatever it is in the court can no longer be adjudicated upon by either the court or this whichever comes.
Let me ask you, Wali. Let me ask you.
In fact, it is the communique of the clerk that is actually, in contempt of the court. Okay. Actually, the communication itself.
Just a yes or no, probably. Your her counsel.
Is one of our counsels. I'm not at the appeal.
Is it possible that she can be advised, as this is the bottleneck, to take this case out of court?
Let's advise the Senate. The Senate should be advised.
Thank you. We'll leave it there, gentlemen.
The Senate is not in court.
We'll leave it there, gentlemen.
The Senate has been taken to court.
We'll leave it there. Thank you so much.
In any case,
they are the respondents. They are also cross-appellants.
And Wali. Thank you so much, gentlemen, for the... How do they say it in Pidgin? Bass-boss. That's how they say it.
It's not a bass-boss. It's just...
All right. Thank you so much. Well, that's it for this edition of our Rice Prime Time. Do join us again tomorrow. For me and the entire team here in Abuja, goodbye, and thank you for watching.